Good morning, ladies and gentlemen. We would like to welcome you to our today webinar. I am Anna Pęczyk-Tofel, a manager in a litigation team of Crido Taxand. I am here today with my colleague Michał Szwed, manager from the from the transfer pricing team in Crido Taxand, and we would like to concentrate during our webcast on the current trends, on the current reality of Polish tax audit. We would like to share with you with our experience in the area of the tax audit. How the tax audit look like currently, and what give you also some indication with respect to how to participate in the tax audit and actually how to survive. We would like to start our webinar with the quotation of coming from the statement of one of the representative of the Ministry of Finance from the last week. And the quotation is as follows. We will act like a hunter, not a fisherman. This was maybe a little bit joke from the side of the representative of the Ministry of Finance, but in our opinion, the statement very well presents the approach of the tax auditors adopted in current tax audit. We would like to start showing you the increasing effectiveness of the tax audit in Poland in the last year. Actually, we have some new data coming from the announcement of the Minister of Finance, and according to this announcement, the total amount of the tax assessment resulting from the audits conducted in the first 3 quarters of this year increased by around 30%, of course, in comparison to the first 3 quarters of 2015. It's a huge increase, and as a result from our experience, and one important information is that this increase in effectiveness of the tax audit is achieved with the simultaneous decrease of the number of the tax audit initiated and conducted in the 3 last quarters. And based on our experience, we can say that we observe many tax audit initiated within our clients than previously. And only looking at our experience and not having those data, we would rather say that the amount of the tax audit conducted is rather higher than previously. But those two data, this higher effectiveness and the less tax audits as result from the announcement of the Minister of Finance, looks like contradict each other. But this is only apparent contradiction. What is important to be underlined, and we would like to explain in more details why this effectiveness is so high. Actually, we see 3 main reasons for this increased effectiveness. First of all, this is competence centers created to support the tax audits in Poland. Second of all, this is a very precise and detailed selection to the control. And the last reason for this effectiveness is the new ways of interpretation of the law, which is used by the tax auditors. And this is three main reasons of the situation. To give you some more information to the as far as the selection process is concerned. What should be underlined is that previously we didn't have any procedure as far as the selection is concerned. It means it was more accidental. Let's say that somebody decided to start the tax audit, but currently the situation changed, and the tax authorities initiate the tax audit only based on information, on analysis, on suspicion that there can be some irregularities with tax settlements of the taxpayers.
Now we think that the strategy will change, even based on this limited reporting that currently tax authorities have. We think that there will be and there are some steps taken just to filter these taxpayers that may have some errors in their tax settlements, or maybe they are just interesting for tax authorities, like companies with the turnover exceeding 1 billion PLN, or, for example, loss makers or companies paying royalties to foreign companies. So what we can observe, and we think that it will be a trend for future, is that the level of hunting actually on these taxpayers will be much more advanced, and that the tax authorities will have better tools, and they will just trying to find the most interesting part of the taxpayers that will be taken into account.
And the second reason of this effectiveness is, as mentioned before, the creation of competence centers in Poland. And there are 4 competence centers created within the most important tax offices in Poland. And the competence centers actually have the best specialists in the area of the specialization of these competence centers. It's important to mention that those competence centers specialize in TP issues, in transfer pricing issues, in optimization, reorganizations, in permanent establishment issues. And the experts, tax auditors collected in those competence centers have very broad knowledge, and they participate actually in all tax audits in Poland, and based on this have, of course, knowledge and experience. But this what need to be mentioned is also the fact that the specialists from those competence centers, they don't participate in in everyday contact with taxpayers, but they only support them from the kitchen. It means they analyze the documents collected during the tax audit, and they give some advices, some indications how to proceed further. That's why sometimes it's difficult to discuss with the issues raised during the audit with the tax auditors, because they simply don't have the knowledge that the competence centers, that the people from the competence centers have, and the discussion is difficult. The last reason for the effectiveness of the tax audit is result from the fact that the tax authorities try to interpret the regulations, the law in such a way that wasn't interpreted before. And actually, it's not the matter of the new regulations, but the matter of the interpretation and testing the new ideas. This is the three main reason. And from our experience result that's the main area of the tax audits. Actually, we have three main area of the tax audit. This is optimization and reorganizations, transfer pricing, and VAT frauds. And we would like to concentrate on the first two because we believe that they are most important in your case.
Yes. Okay. So let's have a look at hot topics in the transfer pricing. What are the main areas of tax audit? Actually, these are the cases that you might find in your business, and we also see that these areas are audited in our clients in the tax proceedings that we are experiencing. Some of them are actually the same for the past years. Some are relatively new. The first one is licenses and IPs. What we can observe is that there is much more pressure on these royalty payments. For example, for the foreign companies, trademark, know-how, any other royalties that are paid abroad. What we experience is that the tax authorities are trying to perform the benchmarking studies just to find out whether the payments are reliable, whether they are arm's length. On the other hand, they are trying to find out where is the value in the value chain, whether the IPs used by the Polish company are developed in Poland or maybe outside. The second matter is the management fees. Actually, coming back to, I don't know, 5 or 10 years ago, there were also discussion about management fees, about source documents, documentation that will support that the services were rendered. Now we are discussing not only about the source documents, but also about the cost basis, what are the detailed information about the costs that were a basis for setting the management fees. What are the allocation keys? What are the benefits on the Polish side, of course, and whether the services could be purchased on the Polish market with a lower price. The another thing is year-end adjustments, which are generally they are acceptable, but you need to prepare a lot of documents supporting that the adjustment was proper. Of course, there's a need to have a strong transfer pricing policy that will support these adjustments, and this adjustment should not only happen when we are talking about decreasing the tax base on the Polish side, but also with the positive result. You should also have the benchmarking study that supports the adjustment that will be supportive, and if possible, it should base on the Polish data. The next thing are international businesses. This is something new because tax authorities for the first time expressed that they will focus more on international transactions than the domestic relations, because they see that this is actually the place where they may find some irregularities. Another thing is the intergroup financing, and this is actually the area that the tax authorities are not very experienced, but this may be an argument actually against the tax authorities, because they simply do not know right now how to perform proper credit risk analysis, what is the arm's length level of interest rate. As an example, we had the case with one of our clients when the subordinated loan in euros granted for a specific investment, which I would say bore a lot of risk related to this debt, was compared by tax authorities to the average level of interest rates on the Polish market for the euro loan. So, this is a completely different way of financing, but still they are doing such horrible mistakes, and you need to go with this to the court just to prove you are right. Another thing is the business restructurings, and this actually follows the OECD regarding the business restructuring, transfer of functions, exit payments, and so on. Typically, they simply ask questions about the benefits, about these transferring of functions, risk, and assets. And last but not least are the benchmarking studies. I think here we have two matters. The first thing is that tax authorities will do benchmarking studies. They perform their own studies based on Amadeus, based on royalty stat or local databases that they use for finding comparables. And the second thing is that they are using the benchmarking studies prepared by taxpayers just to find some mistakes within this analysis, within these studies, and to adjust the results, just to have the assessment without challenging the whole benchmarking study. Yes, and if we have a look at these doubtful tricks that are used by tax authorities, you may find four things that, from our perspective, are not very not very good practice, but still they are doing this. The first thing is the secret comparables. They are using these secret comparables in two ways. The first thing is that they simply ask your competitors what are the prices used in similar transactions, and in this way they are having some information that you wouldn't have. Simply your competitor will not share you with such data, but still they are trying to use it to assess the income. The second way is just to use the data that they already have based on their past tax audits within these taxpayers that are your competitors, and based on that, based on their experiences, they are trying to do the assessment. The second thing, which is actually most common recently, is the cherry picking in the benchmarking studies. They are trying to eliminate some particular companies from the final sample just to manipulate the results. For example, if you have a pan-European benchmarking study that includes data from different markets, and for example, the data from the Polish market are a bit, for example, higher or lower, they will try to eliminate all other companies, leaving only these Polish data, just to have a different arm's length range. And in this way, they are trying to assess the income. This is actually a very common practice recently. Very doubtful, but still they are trying to use it. The third point is the implementation of TP regulations with retroactive effect. Right now, we are not very developed regarding all these regulations about transfer pricing, on how to control, how to audit the transfer prices. But if anything occurs from the OECD side or BEPS, it is immediately adopted by tax authorities, even if it's not directly stated in the tax law. It's very hard to defend the past business restructuring. For example, when you were performing this without having the business restructuring in the tax law at the moment of restructuring. And the fourth point is the wording of TP documentation. Something that we also experience is that tax authorities are trying to find some inconsistencies in transfer pricing documentation, both between the documentation and the background, and between the documentation itself. What they do is simply to challenge part of the documentation that you are providing to them, stating that it does not reflect the background, and based on that they are trying to do assessments. Yes, and this is actually the past. So we are talking about the past information about tax audits, about current situation, and as you may know, in 2017 we are implementing majority of developments regarding the BEPS project. I will not go into details regarding this, but what you should be aware of is that the level of information disclosed to tax authorities after 1st January 2017 will be significantly wider. For example, there will be some kind of CIT-TP form which will be submitted together with tax return, and there will be over 200 questions regarding the functional profile, role in the value chain of the taxpayer, details about transactions, some free of charge payment transactions maybe also, details on financing and IPs. All this information will be used for cherry picking the taxpayers, for eliminating these companies that are maybe not very interesting for them, but also for finding companies that may have potentially some irregularities in transfer pricing. What's more, we are implementing, of course, local file, master file, and benchmarking analysis that should be performed on Polish data solely. But the information provided in these documents, local, master, and benchmarking studies, will be much wider and more precise comparing to the OECD project. There are some specifics on the Polish tax law already proposed. So our recommendation is just to have a look whether the data you provide on a group level meet the Polish standards. Second point is the burden of proof on taxpayer, because if you look into the past, there were no formal obligation to prepare benchmarking study to support arm's length character of the settlements. Now, not only you will have to prepare the benchmarking study in Poland, but also you need to defend the benchmarking study itself, but also the assumptions used for performing the study. For example, search strategy, what companies are eliminated, why we used such approach. There are certain regulations regarding to this, and in our view, this is a completely new reality for the taxpayers. Point number 3 is the interviews with business people, which actually were recently confirmed by Ministry of Finance that their strategy is to discuss not with the tax people, not with the tax staff, but with the business, because they feel that they may receive much more information that affect the level of potential assessment if they discuss it with the business, not the tax staff. In our view, this will have significant consequences, and bearing in mind that these people responsible for auditing transfer prices are seated in this core competences in Warsaw and Łódź in Poland, it is very vital to have very strong documentation that will be consistent with all this information that your business people will talk if tax authorities will come to them. Last but not least, impact of data disclosed in 2017 on auditing past settlements. You should also know that in tax authorities tend to find some irregularities with tax payments, and if they find something in recurring transactions, they open also other years for audit. So based on the fact that in 2017 you will provide them with much more data, as I mentioned above, we think that there may be a trend that they will try to use this information provided to them also to open tax audits for the past years. So we think that it should be analyzed very carefully within the groups whether there are some fragile information provided to tax authorities in 2017.
Mm-hmm. And now going to the optimization and reorganization. It's important to mention that there is a new regulation with respect to the general anti-avoidance rules, but it was implemented in the middle of this year, and but the tax audit concern mostly the previous tax settlements and previous reorganization and optimizations. And there is no legal grounds to verify, for example, business substance to such extent as it have take place currently, based on the previous legal regulations. But this what we observe is that the fact that the tax authorities really try to verify whether the previously conducted optimization have really good business reasons, or only the tax driven let's say reasons. And they very often try to question those optimization, reorganization, as without any regulations that give them the base for this questioning, but they want to try whether this kind of interpretation will find actually acceptance in courts later, when the cases go to the court. What's important about general anti-avoidance rule is also to mention that this may have some retroactive effects, and even if the transaction took place previously, based on those general anti-avoidance rules, the tax authorities may question the benefits resulting from the transaction, and like, for example, interest or depreciations writes off. But they can, of course, not question the transaction as such. And that's why the business substance is such an important element of the control, because maybe we don't see the strong legal grounds for questioning the optimization or the reorganization previously conducted, but taking into account that this may affect, for example, the benefits resulting from those transactions in the future, then it's something important to know. And what is also a kind of trend from the side of the tax authorities is the verification of the tax rulings, because many transactions conducted in the past was secure in the form of the tax ruling, and the tax ruling gives certain level of comfort. For example, the taxpayer doesn't have to pay any areas or interest, or is safe from the point of view of penal fiscal liability. But if the tax authority will be able to, for example, question the ruling to say that it's this what we actually describe in the ruling wasn't true, then they leave the protection, and we have to they are able to assess the taxes according to their interpretation. And as mentioned, this is a kind of trend to questioning the tax ruling received previously. How it looks like they simply verify in very detailed way the agreements, the related documents, whether this what we describe in the background of our application for the ruling was true or it's not true, and if they will be able to indicate indicate that the background was different, or we didn't present all important information from the perspective of tax verification of our application, then they can say that we don't have the protection resulting from the ruling. And this is very often situation during last year, to give the tax authorities simply possibly to reclassify some some transaction to increase the tax burden resulting from those transactions. Especially, for example, they now they concentrate to reclassify transaction conducted on the real estate market, saying that some transaction shouldn't be classified as asset deal but as organized part of enterprise, and based on this, for example, 2% of transfer tax should be paid. But of course, it wasn't based on this that the ruling was different. This is also important to mention that. Because it's that the fact that the penal fiscal liability risk is also higher than before, because if we have more irregularities indicated during the tax audit, then the tax authorities want to, of course, implement also the penal fiscal liability. And the penal fiscal liability can concern also foreigners on the same grounds than that Polish representative of the company responsible for the tax settlements. And having this in mind, it's important to undertake some measure to manage this responsibility. It's possible to maybe not eliminate the responsibility, because of course this is not possible, but to some extent eliminate, reduce the responsibility. And for this purposes, it's necessary to introduce some internal procedures, competence, for example, profiles, to achieve the goal. And of course, it's possible to make some arrangement between the company and the representative to receive some certain level of comfort. And to shortly summarize and to give you some important information about how to behave, how to conduct during the tax audit, simply how to survive. We would like to mention some important points. First of all, it's extremely important to verify the tax settlements before in the area that we expect that can be, for example, questioned during tax audit, and to be prepared for the tax audit. Second of all, it's important to actively participate during the tax audit and presenting the coherent strategy during the tax audit. And this what is important, of course, to a little bit control the tax audit. What we want to say is that we have to staying update on the issue and risk identified during the tax audit, and we have to attempt to make some attempts to persuade the tax auditors to our tax treatment of the transaction or the transfer pricing issues. But if we see that they keep on their stand, then it's important to organize a meeting with and of course it's also important that this meeting will take place with wider, with the presence of the client, with the presence of the taxpayers, of course, with the presence of the tax auditors, but also their supervisors, and to be able to persuade them to our arguments, to our standpoints, and to avoid the next instance, the next steps, the court procedure.
And as for the transfer pricing, we think that the major issue is actually to verify what kind of data you will report to tax authorities in 2017. This will be actually a major difference because today they have very limited data that you provide, the Polish taxpayer provide to the tax authorities. Starting from 2017, this will be a completely new world because they will have much more details that you will give them with the tax return, not in the local file or master file, just the TP form that will be submitted with the corporate income tax return. Will give them much more, I would say, selection criteria, how to find the perfect sample from their perspective and to begin the audits. So first thing is find out what data will be reported and how this will impact your past years. Because as I mentioned, it is quietly probable that if they find something in 2017, they will start to audit past years, having in mind these recurring transactions. The another thing is that business people that are likely to be audited by tax controllers must be aware of TP matters, that they should know what to say and what kind of TP policy the group has, because otherwise you will. It is probable that you will not have a control on the data that will be provided to tax authorities. That sometimes may not be even true. And the another point is the documentation and the policy should be verified whether these documents and the approach used by the group are compliant with the Polish transfer pricing regulations. We think that year 2017 will be still very interesting for tax authorities from the transfer pricing point of view, and they will try to use all these data gathered in their files just to be even more developed in tax assessments.
Mm-hmm. Yes.
Okay. To sum up, we think that the major issue was already presented to you. If you have any other questions after our presentation, please contact us directly. We will provide you with the presentation and the direct contacts to us. If you have any other questions, please write or have a call to us.
Okay. Yes. Thank you
for your
much
time.
for attention. Thank